Looks like everybody's present. Before we begin, anything from the state need to address at all? Mr. Zacher or Mr. Bowles?
Your Honor, yes, the defense has a motion.
Okay.
Your Honor, the state is moving to strike the testimony of Major Hellerud and Brantley Pedrin that has already been presented on the grounds that the state violated its constitutional and statutory disclosure obligations by failing to disclose materially inconsistent and newly developed witness statements prior to trial. In the alternative, the defense moves for a mistrial and asks the court to make the finding that it was the state that provoked the mistrial. I do not say this lightly, but it appears the state may have knowingly elicited perjured testimony. Ms. Dikeman has several overlapping constitutional and statutory grounds to move for these remedies because the state knowingly presented materially altered testimony from child witnesses without disclosure. The state had a continuing constitutional obligation to disclose materially exculpatory and impeachment evidence under Brady v. Maryland, Giglio v. the United States, and Kiles v. Whitley. Wisconsin courts have consistently recognized these obligations. The undisclosed fact that the child witnesses materially changed or contradicted prior statements after prosecution preparation sessions is quintessential impeachment evidence. It directly bears on credibility, suggestibility, reliability, prosecutorial influence, and the integrity of the state's presentation. When the state reviews testimony with child witnesses and the resulting testimony materially differs from discovery disclosures, those changes become independently discoverable impeachment evidence. The state cannot sanitize inconsistent witness statements by replacing prior versions with trial-ready testimony while withholding the existence of the inconsistency itself. The inconsistency is itself exculpatory and impeachment evidence under Brady and Giglio. Furthermore, the suppression of materially inconsistent statements prevented meaningful investigation, preparation of cross-examination, consultation with defense experts regarding suggestibility and coaching, and strategic trial decisions. Wisconsin's criminal discovery statute imposes affirmative disclosure duties on the prosecution. Under WISTAT 971.23 sub 1, the state must disclose written or recorded statements, oral statements, witness statements, and exculpatory evidence. The statute also imposes a continuing duty to disclose under 971.23 sub 7. Quote, if subsequent to compliance with the requirement of this section and prior to or during trial, a party discovers additional material or witnesses previously requested which are subject to discovery or inspection under this section, the party shall promptly notify the other party. In this case, the witnesses altered timelines, added facts, changed allegations, softened prior uncertainty, increased certainty, and materially contradicted prior disclosures. Those changes triggered an immediate duty to supplement discovery. The state had an ongoing statutory obligation to disclose newly developed witness statements. Wisconsin courts recognize that criminal proceedings must satisfy basic notions of due process and fundamental fairness. The core fairness problem here is not merely inconsistency. Witnesses often become inconsistent. The constitutional issue is that the state knew of the inconsistencies, participated in preparation, failed to disclose the changes, and nonetheless presented the revised testimony as substantive evidence. This is classic trial by ambush. The defense prepared its case based upon the discovery provided. The state then presented materially different testimony from key child witnesses after undisclosed preparation sessions. This deprived the defense of the opportunity to investigate the changes, prepare impeachment, retain experts, and so forth. We did not have an opportunity to meaningfully confront the witnesses due to these failures to disclose. Where the prosecution possesses advanced knowledge that a witness will materially depart from prior statements, concealment of that information undermines the truth-seeking function of trial and violates due process. When the state, under Wisconsin law, courts possess broad discretion to impose sanctions for discovery violations, including exclusion. Relevant remedies include exclusion of testimony, striking testimony, mistrial, continuance, adverse inference, or expanded cross-examination. In addition, we have evidence of real-time coaching by the state and have provided the video excerpts in a thumb drive, which has been marked as an exhibit and I will offer after my statement. They are correct. The failure to disclose is obvious. This obvious coaching is appalling. Wisconsin courts are to consider whether there was bad faith in failing to disclose these altered statements, whether there was prejudice to the defense, whether the evidence came as a surprise, and whether lesser remedies can cure the harm. The prejudicial nature of this altered testimony is crystal clear. The defense structured trial preparation around prior disclosures. The inconsistencies were unknown until trial. The witnesses were central to the prosecution. Cross-examination was impaired. Expert consultation regarding suggestibility coaching became impossible. The damage occurred in front of the jury before a meaningful remedy could occur. The prejudice here cannot be cured merely through cross-examination because the defense was denied the opportunity to investigate the origins of the changed testimony before it was presented to the jury. Exclusion is particularly appropriate where the state knowingly elicits materially altered testimony without prior disclosure. So the defense moves to exclude the testimony of the child witnesses. The state prepared these witnesses, reviewed their anticipated testimony, and knew or should have known that the discovery materially departed from prior statements disclosed in discovery.
Okay, so what evidence do you have that they prepared this testimony?
Your Honor, they smoothly went through their presentation without an inkling of surprise at this testimony coming out. They clearly had spoken with their witnesses beforehand and knew what they were going to say.
It's your belief that they prepared both these child witnesses to testify today beforehand, that they knew what they were going to say was different from the original recorded the recordings that were shown earlier.
They must have.
They must have is not evidence. Do you have evidence of this?
There's no other conclusion that they had prepared their witnesses.
Yeah, there is, that the child remembered differently. There's a different conclusion, possibly. But do you have evidence of prepping them, knowing this information beforehand, and then withholding it from you?
Well, certainly Major Hellerud did indicate that they had met and talked about the testimony. One can imagine that
there were two questions. Is that, from my understanding, it was tell the truth, and the second thing was you have to speak out loud. You have to use your words. I think that was what the state had said. They said beforehand. Is it more than that?
we are to believe that they didn't work with the witnesses about their responses?
They said they didn't. Do we have other evidence of it?
Judge, I guess I would ask for the state's rendition on the record here.
Okay.
I will say that my impression of the statute has always been that if an inconsistency comes about during trial preparation or a material fact changes in a manner in which...
No, I understand what the law is, but the question is, did it happen? So I'm going to give the state an opportunity to respond. Go ahead, Mr. Torbenson.
Yeah, Your Honor, the accusation that's just been made in open court is extraordinarily serious, and I wish that it was done with actually more caution because it is such an extraordinarily serious accusation. It has always been my practice when putting a child witness on the stand to tell them what's going to happen in the courtroom and to show them the courtroom. But I specifically do not walk through the testimony question through question for the exact reason that they are putting on the record today, because then it becomes something that has to be disclosed and it may become another inconsistency. So I don't walk them through the testimony. I tell them the topics that will be talked about. I don't ask them questions. I tell them what's going to happen in the courtroom, and I explain the rules of the courtroom, which is what the child witnesses testified to, which is tell the truth and you have to use your words in the courtroom.
Okay, so when you say you go through the topics, did either child respond to those topics and say, this is what I'm going to say, and then you realize, oh wait, that's different?
No, there's no specificity.
No. And did they respond at all to those questions?
I think they indicated or acknowledged an understanding of what we were going to discuss.
Okay. And but as far as any substantive information from them, did you receive anything of substance from them?
No, and Your Honor, the other thing I would say is it was crystal clear from Major's testimony yesterday, and then they can ask the same question of Brantley today. We did not show them the forensic interviews because we also didn't want that to any way influence their testimony. So they have not seen their videos from a number of years ago. So they have no idea what was said in those videos. I suspect that the testimony from Brantley will be the same under cross-examination when asked what he specifically recalls about those videos.
Okay.
The other thing I will tell you, and Ms. Root and I exchanged a number of text messages last night, we were debating whether or not even to play the second forensic interview of Brantley because there was some concern about that the fall that he's disclosing and whether that was one incident or two and whether or not it further confused the jury. So if I knew what he was going to say on the stand today, then why on earth would I be text messaging Ms. Rude last night saying, I don't know if we should play that video? And I would happily share those text messages because I think it demonstrates the ludicrous nature of the accusations that are being made in court.
Yeah, I think what the defense wants me to do is to essentially speculate on, really it's only with Major because, well, I guess it's with Brantley too now on the direct. But the reality is that I can't speculate on facts. You know, because the witnesses or any witness changes their story, it just leads it to, you know, if they don't know that that's going to happen, the state doesn't know what's going to happen, they don't know what's going to happen. Motion is denied. I don't believe there's a basis for it at this point.
Your Honor, I would ask that the court review the coaching excerpts.
Yeah, the coaching excerpts are, I'll take a look at them. And if I change my mind, we can change my mind and I can readdress this motion. Of course, I allow the state to have an opportunity to respond to that.
I have not even seen a copy. I don't know what's being referred to. Nothing's been provided to us.
Yeah, we'll take a look at that.
Judge, just so I understand this, like the state's position is that they, in a first-degree murder case, pending for 3 years, they put child witnesses on the stand, crucial to their case, without discussing what they're going to testify to?
Without going into any of the details with what they're going to testify to on the stand. Correct.
And those accountings just so happen to become consistent with one another after 3 years?
They testified to what they testified to. I actually think they're not wholly consistent. So I don't think I have to defend myself anymore. I think the claim is rather ludicrous.
All right. I deny the motion for now. Obviously, there's some more information you're going to bring to our attention. We can review that. We'll try to review it tomorrow morning and see what we can do.